Hello friends, in the series on the income tax cases, today we will discuss the case of Vedanta Limited versus Deputy Commissioner of Income Tax. This case has been reported in 454 ITR at page number 545 and the matter has been decided by Madras High Court. The date of the judgment is 24th February 2023. The purpose of discussing this case is that at the end of this deliberation, we will come to know that what should be the reasonable period for completing the proceedings for non-deduction of TDS in case of payment to the non-residents. There is section 201 which prescribes the time period for completing the proceedings in case there is default in non-deducting the TDS or non-deposit of TDS on the payments made to the residents. Earlier in section 201, there was no time limit. First of all, time limit of 4 years was introduced. After that, this time limit was increased to 6 years and at present this time limit is 7 years. But section 201 subsection 3 talks about only about the payments made to the resident. So in this particular case, the issue involved was that what should be the reasonable period for completing the proceedings for non-deduction of TDS in case of payments made to non-residents. The department was pleading that since there is no time limit in section 201, so the department can initiate the proceedings or complete the proceedings in a open-ended manner or in a open-ended period. But it was the contention of the assessee that even if the period is not prescribed, then there should be a reasonable period. When this matter travelled to the Madras High Court, the Madras High Court said that the fiscal legislature develops and results by a trial and error method. The court said that when there is no period prescribed for the completion of the proceedings, then there should be a reasonable period in which the proceeding should be completed. The court said that the purpose of deduction of TDS on the payments made to the resident and to the non-resident is the same. The Madras High Court said that in case the time period is not prescribed for completing the proceedings for non-deposit of TDS or non-deduction of TDS on the payments made to the non-residents, then in that case the proceedings should be completed within a reasonable period of time. It is not the case of the department that if the time is not prescribed, then the department has unlimited time for completing the proceedings. The crux of the story was that in this case, the Madras High Court gave a reasonable period for completing the assessment, and at the same time, the court said that when the time period is not prescribed in the statute, then the High Court in a writ petition has plenary powers to decide the reasonable time, and the administrative authorities or the income tax authorities, being the administrative in nature, cannot decide the time for completing the proceedings. So in this case, the Madras High Court, by using its power under Article 226 of the Constitution of India in the writ petition filed by the Assessee, said that the reasonable time is 7 years from the end of the financial year in which the statement of TDS has been filed by the Assessee, and the reasonable period was defined by the Madras High Court. Friends, this case is very important because all we know that when the time limits are not given in the statute, the income tax authorities try to stretch the time like nothing. So this case gives us a guide that how the time limit can be determined by the courts. At the end of this video, once again I am repeating The name of the case is Vedanta Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 454 ITR at page number 545. The matter has been decided by Madras High Court. The date of the judgment is 24th February 2023. Thank you, friends.